troublemakers. And even if they've been there for years under a month-to-month lease, they are most likely going to get a 30-day notice of termination of tenancy, and that's how the process starts. Now, Section 150 prohibits retaliation. If a landlord has retaliated against the tenant, the eviction is to be dismissed, tenant gets damages, and if there's a lawyer, Section 180 says the lawyer gets paid fees. So there's an opportunity not only to defend tenants in the eviction court, but if you have proper facts, you can win on retaliation. Not necessarily an easy thing to do, but you can win on retaliation and earn fees in the process. But, again, I say that's secondary to pro bono. But it's not a bad inducement. What are other inducements for lawyers doing these things? Go back to my example of my first job offer was to be in a library for 2 years. What do you get if you get into this field? And I've talked to a number of young lawyers who just can't find jobs or are not happy with the jobs that they're in and don't want to be in a library for 2 years and do deposition abstracting for the rest of their lives. Well, look at what you do. You can get a chance to prepare an appearance in jury demand and actually go to the clerk's office and file it. And you may begin to bump into people you know there. Then you appear a day, the return day, you appear in court. You actually appear in court and go up in front of a judge. Now, I was nervous when I was a young lawyer going to court. I suspect most of us are a little bit nervous. Hopefully most of us overcome that. But how nice it is to be able to go into court when the court case is called to say, Judge, I filed an appearance in jury demand. And here's the document, and here's the so-called transfer order. Pretty neat. Then you get in front of the judge sitting in 1404. Not a chance to get him. You say, Judge, I'm here on behalf of so-and-so. Case is called. I am asking for 14 days to move answer or otherwise plead with a complaint that I want to initiate discovery. And then you have a chance to prepare those pleadings. Now, it's true that a lot of these cases, maybe the vast majority of them, get settled because when a lot of landlords are faced with this type of a situation, they begin to realize that maybe they should negotiate because their lawyer, one thing I could say good about landlord lawyers is they know how to charge. They know how to keep time records, and they get those time records and bills out monthly, and unless it's a terrifically wonderful client or it's their father-in-law who owns the building or mother-in-law or whatever the case may be, they are going to get paid. It's a tremendous advantage because a lot of what we're talking about doing is you got to wait. It's contingent, and you got to wait. But the process starts. Now, let's suppose you can't settle. Even if you can't settle, you're learning to negotiate. You're getting into being a real lawyer. It's like what you see on television. You are getting to be a real lawyer and get real lawyer experiences. Now, that may not be your cup of tea. You may prefer to do appellate court briefs. You may be great at writing books on various topics. That's a different type of issue, a different type of question. But all of a sudden, you're in the mix. And what else? You're meeting other lawyers. And we're not dummies when it comes, even if you're on the other side. You're getting lawyers, you're getting the mix and mingle. You'll find, I think, that most of the landlord-tenant bar is quite helpful in giving helpful pointers and making suggestions. And by golly, if you get into that mix, maybe then you go to trial before the judge, a bench trial. How long do you think you'd have to wait to do a bench trial? And I don't know if McDermott, Rowe, and Emery puts people in the library for 2 years, or Winston and Strawn, but assuming that they do, how long do you think it would take you to get a bench trial if you went into a large firm? Or if you just couldn't find a job and find a client that would let you do that? And you have a right to the jury trial, as I mentioned. You can do jury instructions, motions in limine, and go to trial and argue before a jury. These are all very challenging things, but what a wonderful opportunity while doing good things in this area of law. And again, 90, as Professor Rose indicated, only 5% of tenants, and this is the Chicago courts, are represented by a lawyer. I mean, I talk to lawyers from time to time and say, well, gee, with all this good information, maybe we shouldn't be giving it away. My response to that is, if all of us today decide to go into landlord and tenant, some of you may do it for pro bono, maybe a case periodically. Some of you may do it, for a little bit of income. Some of you may do it very seriously. But if we could double or triple or quadruple the number of tenants because of this seminar today, that would be a wonderful thing. But that still leave 80 or 85% of tenants unrepresented. Now, how do you get the business? Something I'm trying to be very practical about this, of course, because that's my role here. In astounded at the number of organizations, not-for-profit, 501c3 tax-exempt organizations that there are in and around the city of Chicago that are there to help people. It's astounding. Metropolitan Tenants Organization is one of them. MTO and others are constantly looking for lawyers who they believe have a heart for this, believe in these types of activities that they want to put on their referral list. Well, MTO itself gets over 10,000 phone calls a year from tenants in distress. Now, I'm not here as a promoter of additional resources for MTO, but it is typical, I think, of any number of organizations. Even legal assistance, my understanding is from time to time, they just get as many tenants as they can handle. Lawyers Committee gets as many tenants as they can handle. So even a lot of these organizations are constantly looking for lawyers where what they do isn't enough for a particular tenant. So it's not like you all of a sudden have to join a big golf club for huge dues or start going own a car that you can't afford because you want to do it for show. And I still will not buy a suit that costs retail before discounts $200 or $300. I'm waiting for those deals as opposed to some of our brethren who walk around in $2,000, $3,000 lawsuits. The judges will get to know you. That's not bad either. You'll also hear from senior lawyers that you should join a committee at the bar. You'd be amazed. One of my first bosses told me, if you go to a committee meeting or a seminar and you only get one new idea that you never had before, it's good to go to that seminar. Now we all have CLE to deal with. I think seminar attendance is increasing dramatically. Even I got to an age where I said, well, maybe you got better things to do. But I've been amazed at how much I've learned by going to noon meetings at the Chicago Bar or meetings with the Illinois Bar committees, how much I've learned. And again, you're networking. A lot of the practice of law is networking. If you go up against a lawyer you've never met, you may take an instant dislike to each other. There may be no good reason for it, but we're lawyers, right? Whether it's Perry Mason or Law and Order, where the police push people around even if they turn out to be innocent or whatever, you learn to meet and know other lawyers, and that can be helpful in terms of just going back to Meyer Weinberg. Don't forget, we're still human beings. Act like a human being. Bring your lawyer's skills to the table and settle the matter. What's the statistic? 95% of all cases of all kinds eventually are settled in any event. So there's nothing wrong with settlement. So we talked about client acquisition. We talked about the method of getting clients, which is many. You may have resources of your own. How do you do it? How do you do it? When I did my first paper, John Bartlett hit me on the head a little bit and said, you're giving some good ideas, but what do you do? What do you do? And I'm just telling you, I'm picking up on things I've learned over the years from others. If you got a phone number, the tenants can call because you have a website, the thing to have these days. You'd be amazed at the cases that come through the internet. Somebody's a big shot, they have a security deposit of the condo that they rent, they get a bigger opportunity somewhere else, and I think a lot of owners of condos say, well, they're never going to come back to get that $2,000 deposit, and most of them don't even know that they're covered by the Chicago Residential Landlord Tenant Ordinance. Even if they own only one condominium in a small building, they're covered. Well, the internet, the tenant will search for lawyers on the internet. And if you don't have an internet presence, you're obviously not going to be among the hits that they'll get when they Google or Yahoo the opportunity to find a lawyer. But part of the key to success is when the phone rings, somebody has to answer. Now again, I suspect Lawyers Committee, legal assistants, and a lot of other agencies, if the tenant asks them for help and they can't help, they're going to probably give them a list. The judge might even do the same thing, give them a list of lawyers who do this kind of work. And what would you do if you're a tenant in distress and you've got to go to trial on Wednesday? You ignored it at your peril. Well, you're going to go with maybe the top name, or if there's an ethnic name, maybe you'll choose that name first because you like it, and dial. And you get a voice message. Sorry, not in, blah, blah. We all are busy people.